If you do it again, we will not be here with anybody saying, let's give them medication, let's help them, let's put them in programs. I'm not going to hear it. If you try to contact or communicate with her in any way, you're looking at minimum 2 years up to 20 years in prison. And I'm going to take it very seriously. I can tell you that. Do you understand?
Absolutely.
So whatever the relationship was, it's done.
Yes, ma'am.
And there's no reason for you to ever talk to or communicate with her again. If you do, you'll go to prison. It's that simple.
Yes, ma'am.
Okay. So I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find that count true. Find sufficient evidence to revoke your probation. I'm not going to do that. I'm going to continue you on probation. Again, same condition, not to have any contact or communication. Any issues, you'll be on the mental health caseload if you need any help with whatever it is. Probation's there to help you do that, okay?
Yes.
Yes.
I was wanting to ask you, if I could have any access to a mental hospital or higher release, after I get released.
Talk to probation about that as soon as you're released,
Yes.
because they have options. And if there's something that they can find for you that's inpatient, it's hard to find some inpatient. There's outpatient stuff that you can do. But there might be something that they can do. You need to talk to them about that immediately. Okay.
I'm probation officer.
Yes.
Okay.
As soon as you get out and you're released from custody, go straight to probation, make that appointment, talk to them, explain that you feel like you need some help up front. So that you can be successful later, and I'm sure they'll do everything they can to do that.
Yes.
Okay, thank you.
you.
Go back with the bailiff. And Jody, if you'll just make a note to let his probation officer know that.
Officer is mental health officer.
Okay,
So,
that what he's asking for is, thank you.
Judge, could you pronounce the 45-day jail sanction in this case?
Oh, you didn't say that out loud when he was standing there. Y'all might have said it ahead of time.
Yeah, we said it ahead of time. We said it was a 45-day jail sanction.
With credit
With
for any time?
Yeah.
So there will also be.
He's still got another 2 or 3 weeks to get to serve.
Right. Yep. And Mr. Seegers, the best you can, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you, sir. You can put your hand down. Will your client waive the formal reading of the motion?
He does.
So let's just go through that motion. Mr. Segrist, in cause number 25, DCCR 1836, I have a motion to revoke your community supervision. Shows that you were placed on probation May 18th of 2026 for burglary of a habitation, and that was a 10-year sentence that was probated for 10 years. Is that correct?
I thought it was probation for 5 years.
Shows 10.
It was 10. It was 10 years.
It was 10?
Yes,
I thought it was 5.
Okay. So it looks like it was for 10. And then it alleges that you violated your probation. The only count is count 1. It shows that you violated the conditions of your probation by attempting to contact the victim of the offense, Perla Munoz, through the smart communication messaging system at our jail, May 26th of 2026. And is that true or not true?
It's true, Your Honor.
Did you enter your plea of true to count 1 freely and voluntarily? Is there another?
He's right, Judge.
Is it 5?
Rated for 5.
Oh,
Okay.
10 for 5.
Okay. Well,
I had to double check it 2 places, and it's 10 over 5.
okay. Thank you. Well, thank you for bringing that up. Does the state wish to amend that motion?
Yes, Judge.
Does any objection to
Okay.
that amendment? Okay. So 10-year sentence that was probated for 5 years. And did you enter your plea of true to count 1 freely and voluntarily?
Yes, Your Honor.
And did you plead true to that count because it's actually true?
Yes, Your Honor.
And so it's my understanding that you guys have reached an agreement, Mr. Smith and Mr. Lewis.
Yes, Judge. He's just started on probation. We would ask that the court admonish him that he cannot have any contact with Ms. Munoz, and that we will we offer to keep him on probation, make sure he's on the mental health caseload, stays on his medication, and has no contact whatsoever with Perla Munoz.
So, Mr. Segrist, I have a feeling we probably talked about this at sentencing, that you weren't supposed to have any contact or communication with her. And 8 days after you contacted her, or at least tried to, You are going to end up in prison for
Big judge.
Yeah, so Mr. Seacrest, it was also part of that agreement or recommendation that you serve a 45-day jail sanction as a part of that for you violating the probation. So I am going to order the 45-day jail sanction. I think you have some time left on that. You can have probation. If you can have them maybe go out there while he's there so that as soon as he gets out, maybe there's something in place, that would be great. Thank you. All right, you can go back with the bailiff. Come on up. Good morning. Are you Brad Thomas Thibodeau?
Yes.
And will your client waive the formal reading of the indictment?
He does.
Mr. Thibodeau, in cause number 25 DCCR 0542, you're charged with the state jail felony offense of criminal mischief, impersonating a public service. Is it impersonating or impeding? Hold on. Impeding, sorry. Causing impairment or interruption of public communications. And that's from March 18th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I'm sorry. And I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney's office, you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. There would also be restitution in the amount of $1,848. Is that your understanding?
1,480.
84.
1,484.
84.
Y'all wrote 1848. What's the amount?
All right. 1484.
Okay. $1,484. Is that your understanding?
Yes.
Speak up, please.
Yes, sir.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, sir.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Thibodeau is not competent?
No, Judge.
What is the state's position with regard to waiving pre-sentence?
We've agreed, Judge. He has a 1999 delivery of controlled substance. He received 10 deferred on that. I don't have any indication that he did not successfully complete it, unless he does. And in 2016, he had 20 days on a criminal trespass. With the restitution determined, I have an address for the Windstream Communication Company on 2nd Street in Winnie. It's directly there, so I don't have a problem if you to waive.
All right, so I'm going to waive the pre-sentence report, Mr. Thibodeau, and find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 5 years. You're ordered to pay the fine of $500 as well as restitution in the amount of $1,484 and to follow all of the other rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have a felony conviction on your record. And at the end of the probation, if you successfully complete it, the case will be dismissed. You'll never have the felony conviction. The other side of that is if you violate any condition of probation, you could be brought back into court, found guilty of the offense, and sent to the state jail for anywhere in the range of punishment, which is between 6 months and up to 2 years. Do you understand? It's very important that that restitution get paid from the beginning. A lot of people think, well, I've got 5 years, I'll pay it later. I want you to make payments towards that restitution immediately. Even if it's a little bit every month, get it paid off, okay?
Yes, ma'am.
All right, thank you. Good luck to you, sir.
Yes.
That's the trial court certification. That shows that this was an agreement that I followed, so you waived your right to appeal. All right, good luck to you, sir. Hakeem Manuel Thomas.
Thomas.
Good morning, sir. Are you Hakeem Thomas?
Yes.
And this is 25 DCCR 0843. Mr. Thomas is charged with aggravated robbery. His case is set for trial to begin with jury selection next Monday. And what is the announcement?
Well, Judge, as far as the defense side, we're not ready to proceed at this time. There's some supplemental discovery I've been made aware of that we're looking to get copies of. I guess as soon as I'm able to get that, then I'll be able to assess it and go over with my client, and, so we can prepare from there. But we're still
what's,
Two things, Judge, if I may.
Mhm.
I had a vacation letter in for next week that I submitted in December.
Oh, okay.
I think maybe this one just accidentally tagged along with.
well,
posting it.
and sometimes what we'll do is leave it on a pretrial, and that way if something gets taken
Yes,
care of.
and it happened to be a good thing in this case, and Mr. Wilkerson's here. He represents the co-defendant. I've been working diligently with my investigators to try to get some rather large supplemental discovery from different agencies, not even in a county, DPS in Chambers County Sheriff's Office, video from there. They have sent all that. I received an email with a lot of that yesterday. There's also some things in Fort Bend with respect to older offenses. There's a continuous offense at Port Arthur that goes along with this. So I would prefer to try Mr. Wilkerson's client first. It is set on August 17th. I'll make sure both counsel has that discovery by this week as soon as I get it all downloaded and get it to them in the appropriate format. But that's kind of where I am.
So everybody should have all of it this week.
Everything that's come in. Yes.
Okay. All right, so let's do this. I'm just going to reset Mr. Thomas a normal reset on the trial docket. That gives, since you're on vacation, gives you plenty of time. And then Mr. Wilkerson's, obviously we'll deal with that in about 3 or 4 weeks, which hopefully will give you plenty of time, Mr. Wilkerson, to go over everything, and we'll see where we are on that case. All right, you can go back with the bailiff, sir. No, on a, keep it on the trial. Stacy Tyler. Are you sending all those dismissals on Reyes?
It's mine, Judge. I was told they've already been done.
Why are they on the document? Usually they don't show up if I've already signed it. Okay. Okay.
Bless you.
Bless you. Good morning. Are you Stacy Tyler? And will your client waive the formal reading of the indictment?
She does, sure.
Ms. Tyler, in cause number 26, DCCR 0800, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from March 30th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 15 years in prison, which means if we go forward, you'll be leaving your punishment up to me. I can sentence you to 15 years. I can give you less. It'll all depend on the information that's brought to me at a sentencing hearing. You have an absolute right to have a jury come in and decide 2 things. The first would be to decide if you're guilty or not, and then you could leave your punishment up to them if they found you guilty. If we go forward this way, you're waiving that, and is that what you want to do? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Tyler is not competent?
No objection.
Right, ma'am. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so we can get a pre-sentence report done. And then we'll come back later for that. Anything that you think is important for me to know, get that information to Mr. Lewis, and he'll present it to me on your behalf when we come back. All right? You can go back with the bailiff.
Thank you.
Jim Meldred, Willridge. Yeah. What do we do? Where are we on this? Yes,
The Chambers County case has finally been assigned to the prosecutor yesterday,
oh, good.
so I was able to talk to them. They wanted some time to get with the state here to
Okay.
get some feedback.
So just a normal recess.
Normal reset.
And I did send that discovery to you,
Yeah.
right? Or not not via the normal channels,
Yeah.
but just through an email.
Okay, good. All right, you're Jim Eldrin Willridge. And so, Mr. Willridge, what we're going to do, it sounds like the case in Chambers County has finally been assigned and they're getting some information on that. So what I'm going to do is reset your cases here so they can, your attorney and the district attorney can talk with the attorneys over there, get all that information, see what we can work out, if anything, when you come back at the next court date. All right, you're free to go back with the bailiff.
And I think that next time, Judge, regardless of where we are, probably best to go through the motion in that way, especially since it's out of county. I'll be able to get those people over here and ready, but
For a hearing
will we
after
still
that.
have that one interim setting?
Yeah,
You
yeah.
don't need me to have the next.
No. At the next one, we can interplead.
Please.
And then
Okay.
if there's no agreement, then we'll reset it for sentencing and we can have whatever, sentencing time we need after that.
Okay.
You have plenty of time. Okay, so that's it on this docket. I know I've got 11 o'clock hearing. If you'll give me just a couple of minutes to take a quick break, we'll be right back. Huh?
We have a witness in this case.
And, okay, is it okay just to come up and do it this way? All right, sir, are you Byron Jamal Morris? And Mr. Morris was previously in court, entered pleas of true to counts 2, 3, and 5 in a motion to adjudicate on probation for the second-degree felony offense of burglary of a habitation. I've received an updated pre-sentence report. Have you both received and reviewed that report?
We have, Your Honor.
Yes, Judge.
Are there any additions or corrections to the report?
No, Your Honor.
Not from the state.
All right, and so, Mr. Smith, you've got witness with regard to other allegations?
Yes, Judge, in relation to, count number 1, as well as,
Actually, Judge, count number 4. I think we're not going to change our plan because he did admit to the probation officer that he was intoxicated, but on a different date than the arrest. So I think we can change that to a true.
So let me go through it then. So, Mr. Morris, you pled not true to counts 1 and 4. Count 1 alleges you committed that new offense of public intoxication November 6th of 2025. And in that case, you still want to remain with your
That's still
not true.
Yes.
And then count 4 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you admitted to using alcohol on September 15th of 2025. And is that true or not true?
Yes, ma'am.
It's true?
Yes, ma'am.
Okay, so I will change your plea in count number 4 to true. And Mr. Smith, you have witness with regard to count 1.
yes, Judge.
You may call your first witness.
State calls Officer Jensen.
Yeah, if you'll just kind of slide around a little bit. We'll just do this informally. Thank you, sir. Good morning. If you'll please raise your right hand, do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You may proceed.
Would you state your name for the record and spell it for the court?
Officer Michael Jansen, first name Michael, Michael, last name Jansen, Jantzen.
And how are you employed?
I'm employed by the Beaumont Police Department.
And what is your occupation?
I'm a police officer.
How long have you been a police officer?
A year and around 3 months.
Are you a certified police officer in the state of Texas? What training have you received to become a certified peace officer?
I've been through the basic police officer.
Can I ask y'all both to speak up? Your back's kind of to the court reporter as well. Thank you.
And what do you do? You said you're a patrol officer?
Yes.
What is a duty job description for a patrol officer?
General patrol, respond to calls for service, any number of calls throughout a shift. Could be honestly anything.
Okay. Were you working in that capacity on November 6th of 2025?
Yes, sir.
And about 11:38 in the evening, did you receive a dispatch?
Yes, sir.
And what, if anything, did you do as a result of that dispatch?
Immediately began operating my department issued patrol car in that direction and arrived on scene.
Okay. What did you observe when you got there? And describe for the court what location we talking about.
Yes, sir. 4705 Magnolia. It's the Swift gas station. They're dispatched there in reference to a person that was asleep at a game machine inside that gas station. We arrived on scene, entered the gas station, and observed a person asleep at the game machine. Attempted to arouse him by verbal stimulus. I then reached under his chest and provided a physical stimulus to his chest. He did not wake up. At that point, he woke up after a few more conversations between my partner and I, and he woke up, immediately smelled the smell of alcohol emitting from his breath in person, observed bright glassy eyes, and as we stood him up, we walked him up, to the police car and observed the unsteady gait as well.
Okay. In your opinion, did he appear to be impaired or intoxicated?
Yes, sir.
And did you feel like that was from alcohol and or other substances?
Yes, sir.
Was he impaired to the point that he appeared to be a danger to himself and to others?
Being that the location is in a very high crime area in the city of Beaumont, I absolutely believe so.
And do you see the person that you encountered on November 6th of 2025 at the Swift gas station here in the courtroom today?
Yes, sir.
Would you point to him and identify an article of clothing that he's wearing?
An orange jumpsuit.
Let the record reflect. He hasn't identified the defendant in this case.
The record will so reflect.
And did you place him under arrest for public intoxication on that day?
Yes, sir, I did.
That's what Mr.
Thank you. Mr. Rojas?
So he was in a high crime area, and that makes him a danger to himself or others.
Yes, sir. Being that he was asleep in that gas station that responded to several calls there for violent crimes, he was unable to be aroused by myself and another officer. I believe that somebody could have stolen any number of items from him or assaulted him or been a victim of any other crime.
What was the original call for?
A person asleep at a game machine.
Nobody said anything about anybody being violent or any fighting or anything like that, right?
Not at that time.
Okay. Was there ever at all during this call?
Not during that call, no, sir.
Okay. And when you were finally able to wake him up, he wasn't argumentative or disruptive with you, was he?
He woke up as a person would, surprised that there was two police officers. I feel like that's a normal reaction. That, all of a sudden there's two police officers with their, presence right there. But I was able to take him in handcuffs immediately based off of that reaction. Felt alone.
And you said you did the chest, what's it called? The chest rub?
Like a sternum rub.
The sternum rub. Most people wake up immediately from that, don't they?
Yes.
Even intoxicated people.
General, in my experience.
In your experience, do you know of any kind of what would cause it? But you said he did not immediately wake up from that. What in your experience would cause somebody to not wake up immediately from that? If you know.
Any number of intoxicants in their system.
Okay. Could it also be due to seizures, maybe?
I'm not.
You don't know about that? Okay. You'll agree with if anybody in a high crime area is in a little bit of danger, right?
Yes.
Okay. I'll pass the witness.
Anything
No
else?
other questions, sir.
Any objection to Officer Jansen being excused?
There you are.
Thank you for being here, sir. Any other witnesses?
No, Mr. Judge.
Right. Argument with regard to count one.
I can call Mr. Morris on that, Judge?
On count one?
Yes.
Sure. Raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, go ahead.
Byron, you heard the officer's testimony, right?
Yes, sir.
Okay. And you and I have talked about this before about count one, right?
Yes, sir.
Tell the judge, were you intoxicated on that night?
No, sir.
Okay. Why were you asleep on that night?
I think I had a seizure on the machine.
Okay. And you are prone to seizures, aren't you?
Yes, sir.
And in fact, I think that's in the updated PSI that you do have seizures, and the probation department knows about that.
Yes, sir.
Okay. Now the officer says he smelled some alcohol. Why would he be smelling alcohol on your breath?
The only thing I kind of remember was I might have had an open container in the car. But I really don't remember.
Okay. So you admit that you might have been drinking alcohol on that night,
Might have, yes, sir.
but you don't think you were intoxicated.
No, sir.
And well, pass the witness, Judge.
All right, Mr. Smith.
So, Mr. Morris, you're saying that you had a seizure, and as a result of the seizure, you had passed out to the point that verbal stimulus and physical stimulus did not arouse you, correct?
Yes, sir.
Do you take medication for your seizures?
Yes, sir.
What do you take?
Careful.
How often do you take it?
Grams,
How often do you take it?
twice a day.
Twice a day. Do you know how alcohol affects that?
Not really.
So you have no idea what alcohol does to that drug. It's an anti-seizure medication. Yet you consume your medication twice a day and use alcohol at the same time.
Well, I don't drink like that, y'all, sir.
You don't.
No.
Well, you drink often because you pled true to count 4 and you just admitted that you were drinking on the day that you were arrested. Right?
Yes, sir.
No further questions.
All right. Any other witnesses with regard to count 1?
No, Your Honor.
Any others rebuttal or anything, Mr. Smith? At this time, based on the evidence that's been presented, Mr. Morris, I am going to find count 1 true, that you did commit the offense of public intoxication on November 6th of 2025. So with regard to sentencing, Mr. Rojas?
Judge, Mr. Morris has been on probation since 2016. I think his probation has actually expired since March. It appears that from March of 2016, he was doing well until that first motion to revoke was filed in October of 2020. Notable, I think, as you can see from the updated PSI, at that time, he had some support of both of his parents, who unfortunately passed away, I think the following year, 21, when Mr. Morris was, at that point was sent over to safety relapse in March of 21. And then it looks like at that point, his parents passed away. He went from March 21 to December of 23 until the second motion to revoke was filed based on a new offense that was ultimately dismissed. And that motion was resolved by jail sanctions and continued on probation. And that brings us to this new motion, which is filed from, I think, in February of this year with the new allegations. So he's been on probation for 10 years. Other than this new PI, he hasn't committed any new offenses, even though one was alleged. That case was dismissed in 23. It's unfortunate, I think, that his parents passed away because it looks like they were the support for him. They were able to give him some guidance while he was on probation. He was doing well while they were alive. And even after they passed away, other than administrative violations and this new admitted drug use and alcohol use, which is serious. I understand those are violations of probation, but he seemed to be doing well until this new motion was filed. I don't know what we can do with him, Judge, because probation's expired. My recommendation, or I guess what we would ask the court to do is to let this time that he's been in jail serve as sanctions and let his probation expire.
Right. Thank you. Mr. Smith?
Judge, I believe the recommendation of the probation officer is absolutely spot on. I think he's taken advantage of the court's leniency. We've sent him to SafeP twice. He's been in drop. He's done the moral recognition therapy. He has not gotten any benefit from all the programs that have been offered and completed. He blames the fact that he can't act like an adult because he doesn't have people to tell him what to do, but he's an adult. He shouldn't have to have people tell him what to do. He's been given every opportunity, and just letting it expire would be not justice in this case. We believe that probation should be.
This case just